Something that I guess I should emphasize at this point is that under Maryland, the definition of procurement in Title 21, it says contract administration is part of procurement. So everything that is done in Maryland in contract administration is technically procurement. And everything is done within the confines of the procurement law, the procurement regulations, etc. So we're going to give you some general overview of the lay of the land. And we're going to deal with the Maryland Constitution, the Maryland Procurement Law, and the Maryland Procurement Regulations. All right. Contract management must be done in the context of the entire project of which the contract is a part. And the legal framework is, and this is the order, because you start with the Constitution. The Constitution always sets the overarching requirements within which all law and all regulations have to follow. They have to abide by the state constitution. Then we have the State Finance and Procurement Article, that is the law, and COMAR Title 21, COMAR being Code of Maryland Regulations. And then you have general contracting principles. So this is the things we're going to look at. Maryland Constitution, and I will say this and I will say this again because you will hear this over and over and over, and you probably have heard this previously. Per Article 3, Section 35 of the Constitution of Maryland, extra compensation may not be granted or allowed by the General Assembly to any public officer, agent, servant, or contractor, notice contractor, after the service had been rendered or the contract entered into. And let me do the next slide, and then I'll stop and explain. What this means, without an increase in deliverables, contractors cannot be paid more money after a contract is awarded than is specified in the contract. I'll say that again. Without an increase in deliverables, if nothing has changed, you cannot pay a contractor more money after the contract is awarded than is specified in the contract as it is awarded, as it is signed. It is prohibited indirectly by the Constitution of the state of Maryland. And the next part, any increase in payment has to be commensurate with the increase in performance. You can't have a small increase and pay them 2 or 3 times the amount of money. It must be commensurate. And through the laws passed by the General Assembly, this requirement, prohibition, is passed on to state agencies. Constitution through law to us. Now let me tell you why this came into being, why it came to be part of the state constitution. Supposedly in around the 1840s, there was a history of members of the General Assembly passing laws to give their friends who had state contracts more money. They'd pass a law that says, well, if the contract said we'll give you $10,000, here's a law, the law says give you $15,000. And nothing else changed except a law was passed to give more money. And what happened at that time was that at one point in time, the state of Maryland was on the verge of going bankrupt. And this was one of the reasons that the legislature would continually pass laws to give more money to people for contracts already in place. And if you read the history of the Board of Public Works, you will read something that says that the state treasurer in the 1840s single-handedly bailed out the state and kept it from going bankrupt, that he used his own funds to pay the debts of the state to prevent bankruptcy. And thereafter, in around 1850, the state wrote a new constitution, and they put that provision in the Constitution to say that this could not happen again. And it's been that way now for about 150 years. Was that right? 1850? Yeah, about 150 years. 160 years, yes.
May I just offer, the only time that this has been something that I had to consider was when we had the sharp spike in gasoline prices a few years back, and vendors who were in the business of making pickups and deliveries, such as our Office of the Medical Examiner, they transport bodies all over the state. People who were greatly affected by the increase in gasoline prices threatened to go out of business or change the way they were doing business. So what we did was to increase the payment to them, but they had to give us some additional deliverables. I won't go into what they were, but they were additional deliverables. And everybody wound up temporarily happy.
So you're not going to say whether the increase was commensurate with the increased deliverables? You'll stay silent on that subject.
Right.
Actually, we have a example of that nature, not that exact same example, one of that nature later on in the class today. Well, not today, in the class. 2 days from now, something like that. All right, so this is going to come back and haunt you over and over and over. And any modification that you do, you have to apply this principle. Or any time that you want to give a vendor more money, you have to apply this principle. And if you don't, a control agency such as Budget and Management will, and although I will not say we will never will, the Board of Public Works looked at this also. This is something that is carved in stone, can't give more money without more deliverables. General contract principles. Elements of a contract, offer and acceptance, reality of consent, terms that you may or may never have heard before, meeting of the minds, mutual mistake, consideration, legality, contractual capacity, writing. Offer and acceptance. Now, you don't know this, but we do this all the time. Just think you do a request for proposals, you do an invitation for bids, you do a request for quotes. We are inviting vendors to make us an offer. And under contract law, and this is not Maryland contract law, this is just general contract law, an entity that makes an offer, they make an offer to somebody, and the someone the offer is made to has the right to accept or not accept that offer. So we don't make offers. We invite vendors to make offers to us, and we have the ability to accept or reject those offers. If we accept them, we contract. We can accept the low bid. We can accept the most advantageous offer. And if we don't, everyone else we don't accept. We don't accept the offer from other people. If there is an offer but no acceptance, there is no contract. An offer can have conditions as to whether it is being made only to a specific entity or a group of entities or anyone. Now, one of the things we mentioned just Friday, if you took the planning class, we talked about minimum qualifications for vendors, where you state minimum requirements of references or things of this nature. That falls under this. We have made a condition. We are inviting offers from vendors who meet those minimum qualifications. If we get an offer from anyone who doesn't meet those minimum qualifications, we will reject it because it is not who we invited an offer from. So we don't think of this, but that's what this is. It falls under these legal framework of what's going on within the state. If a party that receives an offer doesn't accept the offer and makes a counteroffer, then the vendor who makes the counteroffer is the entity that's making the offer, and the other party has the right to accept it. But applying this principle to Maryland procurements, vendors are asked, we just went through this, a vendor that accepts our invitation and submits a bid or proposal as the party to make the offer, we have the right to accept the bid or offer if it conforms to the requirements of the invitation. We do not make counteroffers. If someone gives us a bid, we don't come back and say, can you make that bid better? Or I'll give it to you if you give me that for $1,000 rather than $1,200. We do not do counteroffers.
He mentioned that
he didn't do a counteroffer.
Someone who's renewing, we actually go out and say, can you lower your price? Isn't that a counteroffer type of thing?
We have the right to exercise an option, and we are asking them to help make up our mind as to whether we wish to exercise that option. That we will be more inclined to exercise an option if a vendor gives us a better deal. And if they don't, we have to do a procurement. Or we just go ahead and renew it at the price. It depends on the circumstances. But we will deal with that circumstance later, and we will say, if they do make you a better deal, you have to do a contract modification. can't just happen verbally or anything other than a formal contract modification. So we will deal with that later in this class.
Which immediately happens when you do an option, if it goes to the board. They're both done at the same time.
The option happens contingent upon the renewal being exercised. The modification goes into effect immediately. But that requires correct wording of the modification document, so you have to have your attorney involved to make sure you word it properly. But upon the renewal, you immediately get the modification, if it's worded properly. Unless they agree to that it doesn't happen immediately, but it goes into effect a month from now, 6 months from now, whatever. Whatever the circumstance is, has to be in the modification. Let's see, we do not make counter offers, but we can request vendors to revise and resubmit their offers. If you're in sealed proposal, this is what we're supposed to do. If a vendor does not have a perfect proposal, which no vendor is going to have a perfect proposal, there's always something they can do better. We are supposed to go back to them, point out all the areas in which we have some issue with what they have provided, and ask them to resubmit, to answer questions, to give clarifications, to revise their proposal, etc. And each time they do, they're making us a new offer for us to accept or not accept. And then we finally ask for best and final offers, or 2 best and final offers, or 3 best and final offers, whatever the case may be. Reality of consent. For a contract to exist between the party making the offer and the party accepting the offer, they both have to have the same basic understanding of what is being offered and accepted. Maybe not in every detail, but for the most part. And this is what is called meeting of the minds. We both have to generally be in agreement as to what we want and what they're offering, so that when we contract, we know we're talking about the same thing. And although it doesn't come up very often, sometimes when you get in a dispute situation with your contractor and you get into claims and counterclaims and things like that and going to the Board of Contract Appeals, the decision may be that you never both had in the same had agreement of what it was that you were contracting for. And if you don't have a meeting of the minds, you don't have a contract, which I think I say in the next slide. The opposite of a meeting of the minds is mutual mistake. If it is ultimately determined that each party had a different understanding of what it thought it was contracting for. Courts, and courts meaning the district court, the Court of Special Appeals, the Court of Appeals, have the authority of reformation. Reformation means they have the authority to rewrite a contract to harmonize the different understandings between the first party and the second party. So they can go and delve into what each thought they were contracting for and basically rewrite the contract to something that is agreeable to both parties in some fashion. But for the most part, even though the courts have the authority to do this, excuse me, for the most part, we don't deal with the courts of Maryland. It's very, very, very rare that we would ever have a court involved in a state procurement activity. For the most part, what we do have is the Maryland State Board of Contract Appeals, MSBCA. And this is the entity that probably 98% of the time, when there are protests, when there are claims, this is the entity that will resolve these protests or claims. And the State Board of Contract Appeals does not have what are called equitable powers, so they cannot do things like reformation, issue injunctions to prevent contracts from being awarded. They cannot require vendors to do what's called specific performance, and they cannot rescind contracts, etc. They don't have that authority. They can just come up with a decision, and the decision either is voluntarily abided by the parties, or one or the other party goes to court to try and get the decision enforced. Or the court can put aside a decision by the Board of Contract Appeals. So we have reality of consent. Doesn't come into...
The MSBCA is really not a legal entity in the sense that they dictate the decision. They say, this is our finding, now you can voluntarily do it.
They are an administrative body. It's what's called an administrative remedy. And so the Maryland law requires administrative remedies to be exhausted before you go to the court system. And you're right, they don't have the authority to order something.
Because I thought they actually had the
They do their finding. And depending what the finding is, either people do it or they don't do it. If they don't do it, someone can seek a court to force it to be done.
Would the court consider their opinion then?
The court, you have two parties that are going to the Board of Contract Appeals. And so if either party is not satisfied with a ruling by the Court of Appeal, by the Board of Contract Appeals, they can appeal that decision to circuit court.
Right.
And the circuit court, go ahead.
The judge consider what MSBCA suggested?
Yes. The question is, will a judge at a circuit court consider the decision of the Board of Contract Appeals? Yes. And in fact, in almost all instances, when something from the Board of Contract Appeals is appealed to a circuit court, the appeal is handled just on the written testimony and the written findings at the Board of Contract Appeals. They don't have new witnesses, they don't have direct testimony, they simply go on the record. And what they typically do is the decision of the Board of Contract Appeals will stand unless a judge rules that there was misinterpretation of law, that the Board of Contract Appeals didn't apply the proper law in the proper circumstance. So I know of, well, only about four circumstances in the past 30 years that I specifically know of that were appealed from the Board of Contract Appeals to a circuit court. And I don't know of any that were appealed beyond, well, I will take that back, since one we just dealt with on Friday in planning. So now I know of 5 things, and one of which is probably going to be appealed beyond circuit court. But it's very unusual for something to go beyond the Board of Contract Appeals to a circuit court. And aside from what just happened, and that thing that just happened was the Maryland State Retirement Agency that all of us hopefully will be using, some of us a lot more quickly than others. Did I mention I have 35 years, 2 months, and they sued a vendor for money, and they got a judgment at the Board of Contract Appeals for $72.9 million. And the vendor wasn't happy. And so the vendor appealed to Baltimore City Circuit Court, and the circuit court reduced it. They eliminated $34 million of the judgment. There were 2 points to the decision, and they said the one was not applicable, so they eliminated $34 million of the judgment, but left $39 million stand, and the vendor is deciding whether they will appeal that $39 million to the Board of Contract Appeals, to the Court of Special Appeals. I have to keep these things straight myself. So at this point, they have a judgment. The Board of Contract Appeals had a judgment for $79 million or $72.9 million with no enforcement. So then the vendor appealed to circuit court, who does have enforcement powers. The circuit court said 39 yes, 34 no. And if the vendor doesn't appeal, they have to pay $39 million. So that's the only one I know of, and it hasn't yet gone to the Court of Special Appeals, but it may. It all depends whether the vendor thinks that even the $39 million is too high. Or maybe they'll be comfortable that they at least got $34 million off the table. Don't know. Yes?
But if the contracts appeal system, if they have no power to enforce their ruling, why would a vendor say, well, you know, they could say, okay, so you find me, or you want me to pay $72 million, but I'm not.
Then if we say to a vendor pay up and they don't, then we can go to a court and try to get the court to enforce it. So yeah, the Board of Contract Appeals themselves cannot force a vendor to, but we can take their decision to another venue and try to get it enforced there. The courts can. And generally, this is by far the most claim I've ever heard. I mean, I think the most before this I've heard is like $1 million. And in that case, the agency simply withheld $1 million that was due the vendor and kept the money that way. So this is something that the contract is over, and to actually collect the money is going to require some action, but of course no one's taking any action until they get a final decision of how much is owed. But if the vendor does not appeal, then theoretically we will send them a bill for $34 million, $39 million. And I don't know whether they're going to pay it or what the state has to do beyond that. They'll probably just go to court and sue them. Very unusual situation. So let's see, reality of consent. Let's see, if the Maryland State Board of Contract Appeals determines that under a state contract claim that there was a mutual mistake, it will remand the contract back to the parties for them to mutually agree to rewrite the contract. Or if they can't do that, the contract will just end, because the determination is, in reality, it didn't exist. If we had different thoughts of what we were entering into a contract to do, such that I didn't agree with you and you didn't agree with me, we didn't have a contract, since we didn't have reality of consent. So what that means, excuse me, if it is ultimately determined that each party had a different understanding of what it thought it was contracting for, it could be determined that a contract, or perhaps a portion of a contract, never really existed. That doesn't mean there's a termination. That is not a termination for convenience. It's not a termination for default. It's not a void contract. It simply is a contract that isn't. We never had a contract in effect because we never had a meeting of the minds. Now, these are subtle things. They rarely happen. I'm just letting you know that these things can exist. Obviously, it would take a great deal of time and effort to get to the point of determining that a contract never existed. If we have to go to the Board of Contract Appeals for them to determine there was a mutual mistake, we've gone through a whole lot of effort and time and expense to get to the point that, guess what, folks? You never had a contract to begin with, which is a bad outcome. And what that generally means is somewhere in everything that's gone prior to that date, we haven't done things right. To enter into a contract with a vendor that ultimately is determined that there was no contract means there's a failure in what we have done to vet the contractor, to make sure they understand the contract. As you pointed out, at the pre-bid conference, there's opportunity to discuss. If it's an evaluated contract, there's opportunity to discuss with oral presentations, with cure letters, and to get to this outcome when you have myriads of opportunities to clarify and to make sure there is understanding, only to get to the point of, guess what, folks, mutual mistake, there is no contract, means there has been a failing in what has happened before this. And we shouldn't get there. And usually we don't. But lots of times we have situations that don't get to this level, but we have claims from vendors, we have ambiguity, we have things we cannot enforce because, to a degree, we didn't do a sufficient job of making sure there was this understanding, picking the right vendor, making sure there was understanding of what we're contracting for. So all this is part and parcel. It's an entire process, and everything has to be done right to get the right results at the end. Let's see. Consideration simply means something of value given by one party to a contract to another for the benefit obtained. Something in consideration. We pay vendors money almost all the time. That's what the consideration is. But sometimes we can simply give the vendor the right to do something or to get money from someone else, such as the public. And if there is no consideration, there is no contract. This is not something we generally deal with because we have consideration. We pay money. Legality. Contracts cannot be legally enforced if they were entered into for illegal purposes. Now, obviously, we would not, as a state, enter into an illegal contract. I certainly hope we wouldn't. For instance, one party cannot sue another party for breach of a contract if the contract was for a party to steal, because that is not something that's legal. Sell people, burn down a building for insurance money. These are illegal activities, so you can't enforce a contract for an illegal activity. And if you ever read The Merchant of Venice or remember my discussion in the planning class where a contract to give a pound of flesh was unenforceable because of little details like you can't get exactly a pound of flesh, you can't stop blood, and I think there was one other little thing that it was illegal to harm a citizen of Venice, and so the person who wanted to collect his pound of flesh wasn't allowed to do it because it was an illegal purpose. So that doesn't happen very often. Now this is something that does come into play occasionally. Contractual capacity. A contract is not legally enforceable if one of the parties does not have the legal capacity to enter into the contract. Now, we generally don't deal with minors and persons that are mentally competent and things like that. But the third one there, persons who misrepresent their authority. When you have a vendor that's giving you an offer, when you have a vendor, you have people signing for a company, does the person who signed have the authority to bind the company to what the offer, to the bid, etc.? That's one of the things you should be looking at. Do they have the capacity to bind the vendor? You'll want to know what authority they have. And this also works from the state standpoint. Let me see. An entity may not be bound to a contract if the person who entered into the contract allegedly on behalf of the entity did not have the authority to do so. And agency authority doesn't mean a state agency. It's just a term of legality, which I don't know why it's called agency. But we're going to deal with that. Writing, written contract. Okay, state of Maryland procurement contracts have to be in writing in order to be enforceable. Remember, you heard that from here. And here's a decision of the Board of Contract Appeals. In order for any recovery to be considered, a procurement contract must exist. And if you go to 11.202 and 15.217 of the State Finance and Procurement article, you will find words that basically say a procurement contract must be in writing. So it has to be in writing. Let's see. Agency. We talked about the legal capacity. Now we're going to deal with that in three different aspects to that. Express authority, and that's when someone has authority by clear language. They clearly identified as having specific authority. Implied authority, not granted by clear language, but that which is reasonably necessary to carry out express authority. And apparent authority. No actual authority is present. The issue generally arises when an agent has clearly exceeded actual authority. Now, why these are important? State of Maryland does not recognize implied or apparent authority of state officials and employees in procurement, meaning that if any of you enter into a contract or seemingly enter into a contract or a modification to bind the state of Maryland, and you did not specifically have the authority to do that, the state of Maryland can repudiate anything and everything that you have done, because it does not recognize implied or apparent authority. It only recognizes express authority. Express authority is what is stated in the Finance and Procurement article in Comar Title 21, meaning the Board of Public Works has authority, control agencies such as Budget and Management have authority, DHMH, Environment, General Services has authority from the Board of Public Works, but unless you have an authority in law or regulation, you don't have that authority. And if you take an action that didn't have authority, the state can walk away from it. Deal with that some more. If an official does not have actual express authority to enter into a contract modification, the state is not bound by any action done by that person. The state can repudiate. Alternatively, and this will sound familiar to a number of you, unfortunately, officials with actual state authority, and those officials mean the Board of Public Works, can ratify the action of state personnel who acted on implied or apparent authority but without express authority. And they do that by finding a procurement action to be voidable, meaning they can ratify it by their authority. So the most typical example of this is retroactive items. Retroactive, you want the board to approve something after it's happened. The board can approve it or not approve it. Excuse me. If they approve it, they have ratified it as being a voidable contract. If they don't approve it, it is void. So it's that simple. Void means it didn't happen. So that's where this comes into play. And we will discuss voidable later on. And the thing I will say is none of these slide numbers are exactly correct. We keep changing this class. So I think right now that slide number is off by at least 3, and by the time this is done, it'll be off by more than 3. So you'll have to get the final version whenever we're done with it. We keep playing with it.
Question.
Yes?
Sometimes we get involved in emergency procurements that are approved up to, say, the COO and Chief Operating Officer. That would not be a contract that would fall into this where it could be a void contract, because we've entered into a contract technically with a contractor.
State law gives all agencies the authority to declare emergencies. And so you have the authority to declare emergencies under defined circumstances, sudden, unexpected action that could not be reasonably foreseen, that needs an immediate action to prevent or mitigate actual harm to public health, safety, and welfare. So if you have something you feel that meets that definition, you have the authority to declare an emergency. And since you have the authority, you did something within your authority. Other than an emergency, it has to go and get the proper approvals, otherwise you didn't have the authority. Let's see. The concept of implied and apparent authority does apply to vendors. It does not apply to the state, it does apply to your vendors. And so, if an official of a vendor signs a bid or transmits a proposal, the vendor can be held to the contents of those documents if the official seemed to be in a position to represent the vendor, even if the vendor later says the official didn't have the authority to enter into it. So you can get into a claim situation or some kind of legal situation of, did the person who signed the contract have the authority for the vendor? And if they seem to be in a position, well, yes, they're the president of the company, we would think they would have the authority, it can be enforced against them. And the difference, let's see, oral direction, I'm going to get to something in a moment. Oral direction or promises made by state officials and employees cannot modify the state's obligations under a procurement contract. The only way a state contract can be modified is in writing with the same approvals that are required for a modification. Another Board of Contract Appeals decision, and there have been many Board of Contract decisions. We are unable to find any oral agreement, either expressed or implied, through conduct to modify provisions in the contract, notwithstanding a requirement that all changes be in writing. So the requirement has to be in writing, and even if there's alleged that it was verbal, they will look to something that is in writing before they will seek to enforce it. Why the difference between the state and the private sector? Why do we recognize implied and apparent authority for private vendors when it is not recognized for the state? And it's very simple. For the state, all authority and lack of authority is clearly identified in law and regulation. Anybody can go to the state finance and procurement article. Anyone can go to Title 21 and see who has authority, because it's all there. Anyone cannot go necessarily to IBM and see who has authority in IBM to do what. And so that's why everyone can find out who has authority in the state. We typically cannot find out who has authority in private vendors. So state, if you don't have the authority, state can walk away. Now it usually doesn't. Usually the state will uphold the action that you did. They will make a contract voidable. They will ratify it because they don't want the results that might happen if they did walk away from what seemed to be a valid agreement with a contractor. But they could. All right, let's see, parole evidence. When parties have intended the written agreement to be the complete understanding of the parties, other written or oral evidence cannot be permitted to vary, alter, or modify the terms of the contract. You frequently will see the language that any change must be in writing and must be agreed by the parties so that everyone can tell what the agreement is. If it's not in writing, how does anyone know what has been agreed? If you are the contract manager and you leave and someone follows you How do they know what they're supposed to manage if supposedly the contract has been changed verbally and no one knows what it's been changed to? Which, of course, they're not allowed to do, is change it verbally. So it has to be in writing. If it's not in writing, it isn't. It's that simple. Charges of mistake or fraud can be proven by evidence contrary to the written documents. So occasionally a court can accept something to prove that what was in writing isn't what was intended, but that's not typical. Agreements, and here's the thing that's most crucial. Agreements after the contract has been signed are not covered by the parole evidence rule, but if the contract is required to be in writing, modifications to the contract must be in writing also. Modifications must be in writing. And the corollary to that is, and they must be approved as required by Title 21. We're not going to go very much further on this. Fraud, false statement or act of concealment by one party to a contract of a material fact with intent to deceive. That is fraud. And we do have a clause that's not a mandatory clause, but it's typically a clause that's included in state contracts that has to do with false information, Mark, what's that called? False something or other. False contents, false information, something. And it deals with this, the element of fraud. So if you have fraud, you have to have, number one, the first part. You have to have a false statement or act of concealment of a material fact with intent to deceive, You knew it was false. Reasonable reliance on that statement or concealment by the party to the contract claiming fraud. So the other party must have really believed it and must have had reason to believe it. And there must be actual harm or injury as a result of that reliance. If you have those three things, you have fraud. And if we prove a vendor has done something fraudulently, then we can go against them and get money damages. And in fact, the state law allows them to go, it is a criminal activity. They can be sent to jail for fraud, things of this nature. Rules of construction. And this is something that in the planning class we dealt with, and we will deal with this a little bit in this class. Doubtful or ambiguous language is construed against the party who drew the contract or chose the language. Now, how many of you have ever bid a state contract that was written by a contractor? Anyone here have ever had a vendor write your contract and then you put it out for bid for the vendors to respond to after they wrote the specifications for you? Thankfully, none of you have. Because we write the contracts, what that means is we're on the ones that are on the hook for this. If we write something that is ambiguous, we are the one that potentially can have whatever we wrote construed to mean what the vendor says it means rather than what we think it means. And in the planning class, we dealt with what's called patent ambiguity and latent ambiguity. Patent ambiguity means it's obvious. It's an obvious problem. And the standard is for an obvious ambiguity, the vendor is required to ask questions and get clarification of the ambiguity. And if the vendor doesn't, the interpretation of what the ambiguity means will be the interpretation of the state. Conversely, if it's what's called a latent ambiguity or one that isn't obvious, the interpretation that will prevail will be the interpretation of the vendor. So we try to avoid ambiguity because we don't want a vendor saying what our contract means. So that's part of the rules of construction. That's how that comes to be because of this requirement. This is not real elementary. Words and phrases are to be given their normal meaning. You take what they normally mean, not some kind of really esoteric statement that it means something contrary to what anyone else thinks it means. Where there is printing, typewritten, or handwritten handwriting on a contract document. Typewriting will prevail over printing, and handwriting will prevail under typewriting. So that's why if you have something handwritten by a vendor, you have it initialed, you have it dated, because whatever is handwritten will supersede what is there before the handwriting. And this is why it's there, because it's the rules of contract construction that says that's the way it is interpreted. Okay, any questions on those things? I know you were all dying to learn those things of contract law, and you're saying, okay, we've gotten through that, so let's get on to something worthwhile. These are the number of things we're going to talk about over the next 4 days on contract administration. These and, well, those things. So we'll deal with these generally one at a time. What I will say to you, and this is something that Mark dealt with this morning, what we're going to emphasize over and over is the best way to handle these things is to put them in a solicitation or contract to begin with. It's almost always better to have it in there so vendors can deal with it, so they can price it, than for you to try to have it done after the fact. Let's see. It's best to include a desired contract management action in the solicitation or contract as a deliverable than to try to modify the contract later or have the contractor comply voluntarily, because those are your two choices later. You either do a contract modification or you don't do a modification, and you just hope the vendor will do it just to do it. And neither one of those is as good an option. Obviously, voluntary means they're only going to do what they're going to do, and modification means both of us have veto power. We have to have the mutual agreement, and if we don't have a modification. So they basically have a veto power over what we want if they don't agree to it, unless there's something called a change order, which we get to later. If a requirement is not originally contained in the contract, the agency, number one, may not get the same level of compliance if they try to add it later. Number two, may have to pay more for it, because the vendor's always going to claim it's going to cost more if you want it after the fact. That's something you should figure on. If you try to get it later, you're going to pay more for it. And the other thing, if you're doing a sealed proposal procurement and sometimes multi-step sealed bidding procurement, you can have these issues included as part of the evaluation to see whether the vendor can and will do these things. If it's not in there in advance, you cannot consider it in the evaluation. Let's see. Contract administration. So we're going to start with overview. We're going to deal with these four things. Something that is said if you take the overview class. And did you mention that we're going to have 7 classes?
No. Oh, no.
All right. We, at this point, have, well, if I can say it this way, 4 classes in the hopper with 3 more to come. We have an overview class of procurement, a planning class of procurement, a procuring class, a performing class. We will have a sealed proposals class. We have a pricing class that is 95% done. We will have a class on insurance and bonding, and we will have a class on MBE, small business reserve, the preference type things. So in the overview class, which is overview is 2 days, procure is 3 days, planning is 6 days, this is 5 days, pricing will probably be 4 days, bonding and insurance is 1 day, and the preferences isn't written yet, but it'll probably be 2 to 3 days. So in the overview class, one of the things we tell you right up front is contract management begins on the day that you decide to procure something, because everything that you do from that point in time should be with the focus on the end result. Getting the end result, and how do you get the end result? Everything should be written from the standpoint of trying to maximize the result to be obtained and how we can assure that we're getting what we supposedly are paying for. So that's the first principle. Second one is you want oversight. We will deal with this in a slide or so. It's a two-way street, number 3, and communication. So these other 3 we will deal with shortly, such as right now. Oversight, not direction. The purpose of contract management is to verify if the contractor is doing what the contract requires, i.e. yes or no, yes it is, no it isn't. And if it isn't, then we should note the deficiency and we should tell them they need to address the deficiency. But what we don't do is tell them exactly what they must do. They must meet the contract requirements. Telling them how to do it is generally beyond our purview. Just do it. We're not going to tell you how many people you have to involve, or we're not going to tell you all the resources that you have to involve. Just do what you contracted to do. We'll tell you when you're not doing it, but how you get to do it is up to you. State should meet its obligation. A contractor cannot be expected to meet all its obligations under a contract if the state does not do likewise. If we don't hold up our end of the bargain, how can we expect a vendor to hold up their end of the bargain, particularly if what we are supposed to do is they have to rely upon our actions to do what they have to do. If they can't take an action until we make a decision and tell them what is allowed to happen or not allowed to happen, they can't move. If we have to give them data and don't give them the data, they can't move. If they have to get information from another contractor and we don't make that other contractor give them the information or do whatever's necessary, they can't do what they need to do. So we need to uphold our part of the bargain. Communications, and we will deal with communications for a number of slides here. Simple rules should be followed in communicating with vendors, which will be in about 15 slides. For large, complex contracts, there should be established procedures for contract communications. Now, this is something that may be new to a lot of you, and this does not happen for every contract, because this probably is a little too much for most routine contracts. But for major contracts, you may want this to be in place. So you have to decide which of these things you want to apply, to have in your contracts and which you don't. So we're going to suggest that for major complex contracts, there be actual procedures for communicating in normal situations and emergency situations and unresolved situations. So, and contacts. Who to contact in each of these from the vendor. All right, we're going to deal with this. The requirement for contact information, including contacts for unusual situations. So this is what you might have as a requirement for the vendor to give you. Let's see. So the requirement for this should be contained as a deliverable in solicitations and contracts. Again, not all of them, but when you think this is an appropriate situation. You put it as a requirement that they have to give you this communication procedure. Excuse me. As Gary told you this morning, I had a cold. I still, to a degree, have a cold. At times I have difficulty talking. As a deliverable, it can be specified what type of information is to be provided. So if you tell a vendor, as they are providing a bid to you, or more particularly a proposal to you, that they have to include this information, you can tell them specifically what they must include. Relative to communications or contact within the vendor. Who are they? What is their position? What is their cell phone number? What is their office telephone number? What is their fax number? What is their email number? So that you can get a hold of them. When you tell them when this information is to be provided. So not only who is it that we should be able to contact within the company, but do they have to give you this as part of their initial response? Do they have to give you this 10 days before the contract starts? Just when do they have to do it, and when do they have to update it? Presumably each time someone changes, they give you an update to the contact list. You can ask them, if you're doing an evaluation, you can ask them, how many customers they have provided this type of list to? How many other customers supposedly have this same ability to contact people? And what you can do for an evaluated procurement is contact those customers and see whether this is just a fictitious list or whether they've actually used it. Can the references authenticate that they have called these people and gotten action because they were the right people and the right phone numbers and things like that, so you can evaluate the propriety of this information from people who have used it before. And you can also have liquidated damages if you say, give us this information for escalation of problems, etc., and it doesn't work. And we'll talk about liquidated damages later in this class. For sealed bidding, I'm going to differentiate between sealed bidding and sealed proposals. And if anything I'm saying you have questions on, ask questions, because I realize I've been rattling off very freely. But if you have questions and want to make comments, please go ahead and ask the question, make the comment, because I want your involvement as much as possible. If you have situations where you want to know if something applies to something you're doing, ask a question. All right, sealed bidding. Normally the deliverable, what we just talked about, this contact list, would be satisfied after the contract is awarded. Since in sealed bidding you don't do evaluations. You take the lowest bidder that's responsive and responsible. So this is something you would have as a contract requirement that you would not evaluate by. So you would tell them within X days of the award or X days before the contract starts or X days after the contract starts to provide this information. For sealed proposal, contract communication can still be a deliverable that they have to give you, but you can have them put that in their proposal, and you can evaluate how detailed the communication is, the escalation procedure is, and you can have the reference of customers that have used that. You can go to them, ask them if they have used it, have they been satisfied with it, and how frequently they've had to avail themselves of it. So it's just something you can do. Now, if you did not put this in up front, if you did not in your specifications write down that there had to be this escalation procedure, you can still go to the vendor after the contract is awarded and ask them to give you this information. They should probably, hopefully, will have no problem giving you information on who to contact if there's issues. So, but you don't have the same right to demand it. You don't have the same right to say, change it every so often. When you're going to them and asking them to do something, then it's more of what they're willing to do than what they're required to do. So even though it doesn't say you don't try to get this if you didn't do it up front, it's always better to do it up front. Let's see. Presumably a no-cost modification might be requested to require the information. Presumably it wouldn't be a cost for them to tell you who to contact if there's problems. But vendors should be willing to provide this information even without a contract requirement to do so, unless, and this is a thing that can happen, if they say, well, we don't have any type of problem escalation procedure. That might be their answer. We don't have one. And if they don't have one, you can't require them to establish one. Whereas if you did it as a contract requirement, you could. All right. Again, dealing with major contracts, you can have what's called the problem escalation procedure. And you can specify this in your specifications. And this is beyond just a contact list. This is a formal procedure for escalation of problems. So for major contracts requiring continuing strict performance, the contractor can be required to provide and maintain a problem escalation procedure both for routine and emergency situations. For routine problem situations, the chain might start with the contractor's contract manager or a help desk. So if there's a problem, maybe the first step is you go to either the vendor's contract manager, or if they have a help desk, you go to the vendor's help desk. Now the issue is, what happens if it simply sits there for a while? And this is why we say it should be an escalation procedure, that you have a formal structure for where it goes after a certain point in time without resolution. And you should have it broken down, routine, emergency, and should include things like problems in evenings, problems on weekends, problems on holidays, so no matter when something happens, there is a procedure supposedly to take care of it at that point in time. Someone from the vendor that's supposed to be contacted with specific information of their phone number, their email address, etc., for them to start this in getting rectified, the problem rectified.
Question.
Yes?
How come that isn't one of these mandatory boilerplate clauses?
Well, it isn't mandatory because for most state procurements are small. When you talk about how many procurements are done, probably 90% of them are, what, under $25,000? And when you go to the ones that are in the tens of thousands, the hundreds of thousands, it's just not a requirement.
I thought there would have been a good 10 or 20 or 30% like that, but that's not the case.
Not from an actual number of ones that are issued. But of course, the ones that are of the millions of dollars, even though you only have like 10% of those, they probably represent 80% of the cost of all contracts. The ones that have the big value but are few in number. But it's not a mandatory clause.
Yeah, because like that healthcare contract that you were talking about providing nurses, I would think that you can't provide one, and that now you move to an emergency situation maybe, or have to contact someone. I would have just thought that would have been a standard.
It's a prudent requirement, but there's a difference between what's prudent and what's required in law. In law, someone has to pass a law that says it's required. And it's a lot harder to pass a law than it is to just write something that makes sense. So, and the reason why I'm telling this to you, and from your standpoint, seemingly this makes sense, well, a lot of people just don't think of these things. And you need to, at some point, think of them, and once you think of them, then do I have a situation that this seems to apply? And if it does, write it in your specs, and then make sure the vendor does it. Oh, let's see. Ensure that the procedure for non-normal working hours contact seems reasonable. It isn't just one person's cell phone number anytime, day or night. And the reason why I said that is I had this one time, that it turned out that one person was supposed to be the contact for every customer, no matter what happened. And I remember asking the vendor, well, does this person ever take a vacation? And the answer I got was, he takes his cell phone with him. And I'm like, I'm sure his wife will be delighted that wherever he is in the country, he will have his cell phone, and every customer of this vendor is going to be calling him day and night, wherever he is, for complaints. And I said, that doesn't seem reasonable to me. What do you do when this person is sick? What do you do if he leaves? Who beyond that do we contact? Well, it's worked so far. And I'm thinking, I never want to be that person that has to answer every phone call from everybody potentially that in any way is a customer for this vendor. So to me, that's not reasonable. This would be inadequate because no single person can always be available. Sometimes they sleep, sometimes they're on vacation, et cetera, et cetera. The problem escalation procedure, that's what we're talking about, problem escalation procedure, should detail the complaint confirmation process. You want to make sure the vendor acknowledges that they have received a complaint. The time that they received the complaint, they acknowledge what the complaint was, so that you know it's in the system. The maximum duration for a problem to remain unresolved at this level before automatically escalating to a higher level. Do they wait 1 day? Do they wait 5 hours? Do they wait 2 days? So the initial point of contact, they should explain to you how long before, if something isn't done, it goes to a higher level with increased attention to try to get it done, so that you can evaluate whether that seems reasonable. Circumstances in which the escalation will occur in less than the normal elapsed time frame. It's an emergency. We can't allow 3 days at this level. We need something done. So you want to know what they acknowledged as an emergency or a circumstance that will allow you to bypass the normal procedure. The nature of feedback. Okay, you get an acknowledgement that initially you filed a complaint, but you also want to know that something's happening. So do they every day, every 6 hours come back to you and say, okay, this has been referred to such and such location within the company, and we expect within X time they should have a resolution so that you at least have some feedback to know what's going on. So we're suggesting that is something that you ask for. The type of feedback they would normally provide to you and the time frame for doing it. And finally, the progressively higher levels that would become involved in resolving the problem. The longer it goes on, you want it to keep going up the company chain till someone gets to the point they can do something about it. Excuse me. The progressively higher complaint resolution levels should have the same information provided as for the initial complaint level. The name, the position, the phone numbers, the email address, the pager, all that information, you should have it for each step along this escalation chain. And the problem escalation chain could have multiple levels all the way to the present. Sometimes we've had it where they said the final point is within, let's say, 5 days it isn't resolved, it goes to the president, and the president makes something happen. But I want to emphasize is this point. The degree to which a vendor has a procedure of this nature established, in other words, they're not inventing it just for you, but they already have something of this nature, indicates to you, very possibly, how seriously they value customer service. Because if they have this formalized, that means they hopefully intend to deal with problems. Versus if you put it in your specifications and they say, what is this? What do you mean? Escalation procedure going, well, you just complain. You know that either they never have a complaint or they just don't deal with them. And that's what you need to find out if it's an evaluated procurement. So these are suggestions for something that may apply to certain contracts. And aside from the normal situation, we want to know if it's an emergency where we can't wait the normal time frame, then what is going to be different than during the normal procedure? What steps might be bypassed? What time frames will be shortened? Additional contact information, additional feedback, what happens for an emergency versus routine. So in the right contract, all of this should be in there so that you have somebody to contact to try to get problems resolved. I think that's all. Okay, we're going to have an example. Any questions on that so far? Anything you want to say while I'm taking a drink of water?
No, Mark?
I'm stalling for time.
No, I just think that most corporations are set up.
Talk to the mic.
I just think that most corporations are set
See,
up
you say something literal.
based on the nature of the contract. Most of these companies are set up in a way that it says if you can't get in touch with me, then you got to call Joel. And if Joel's not available, then you go up the line that way. I mean, this is not unnormal for most organizations that operate around the clock.
Or it shouldn't be.
Or of high priority or of high importance, where it's customer service or it's 24-hour operations or if it's affecting the public. This is routine. They've got these procedures built in place that, I mean, if you call our office, you're never going to get me, so it has to go up to the next person in line.
Hey,
most people,
they can't get you, they can't get me.
Most companies understand that when the client calls, regardless if it's the state or anybody else, somebody's got to answer the phone. Somebody's got to resolve the situation, regardless of what led to the creation of that situation. Somebody needs to answer the phone to solve that problem. So this isn't really unnormal in most situations, and it's only required if you've got a contract that is going to be 24 hours a day, or it does have an impact on the public, or the impact on their ability to provide a service, or it is mandated by the federal government. Some situation where you can't have any lapse, and you got to have somebody answer the phone. There's nothing more aggravating than calling in an emergency situation and nobody's there. or you find out the line's dead or something.
Nowadays, you get an answering company.
You get an answering machine, you know, like.
Well,
or you
but
get
that's
an
what you need to
answering
ask for. Who's going to answer
Yeah,
it?
you
What
may get-
authority do they have?
You're right, you may get a private company that's there just to answer their calls, and then
Pass it on.
we'll pass it on to whoever needs to get this, and they'll get back to you, so.
Gary does have something to say.
Well, only because if it winds up where this comes to me, and I'm not saying this because of what anybody else, you know, might do in a similar situation, but if the problem is so bad, so terrible, and it's happened at least 3 or 4, maybe 5 times since I've been here, where there's a total breakdown of communications, a total challenge to get what it is that we bargained for. What I do is to ignore any chain of command, and I start at the top. But that's just me. That's how I grew up. That's how I learned to solve a problem. I don't recommend that to do, but whoever it is in your organization, DHMH, it would be me, but whoever it is in your organization, they need to solve your problem. And they're not going to solve it by talking to the same people that you've spoken to. And I find that when I call the president of a company and I tell them that if he doesn't get involved in this immediately, we're going to consider our cancellation for cause, our termination for cause option. And I do a little bit of explanation on that, not as a threat, just as an explanation. I find that the attention gets put on our contract. And it may not be through anybody's fault other than the guy who you last spoke to wasn't able to escalate it beyond that. And his or her authority was limited. So I'd suggest that whoever your procurement person is, if you have to bring it to them, maybe that's what you should be expecting.
Okay. Hopefully you won't go there for every complaint right off the bat. But as Gary said, he's done that, and I know he's done that in instances where he's had some problems that haven't been resolved for a period of time at a lower level. And as he does say, when it gets to the top of the chain, usually that's the first they hear about things like this. And they don't like to hear about things like this. So they generally will get something done. So let's go with a real example. And some of you might have heard this before in planning. A state residential facility, an unknown state residential facility located in Catonsville, Maryland, with the name Spring in the first name and Grove in the last name. But other than that, I'm not saying where this was. A laboratory services contract has a provision that anytime a doctor deems emergency testing as being necessary, the specimen must be picked up from the agency within 2 hours of notification, and the testing must commence immediately upon arrival of the specimen at the lab facility. So that is in the contract specification for laboratory services. And that's deemed a stat situation. And it may only happen once every couple years that there even is a stat situation. Less than a year into the current 3-year contract, such a stat situation occurred about 2 o'clock on a Sunday morning. Telephone number for the contractor, which is called for routine situations, is called, but there is no answer. So the nursing staff that's there 24 hours a day has a phone number to contact the laboratory company, and at 2 o'clock on the Sunday morning when they need a stat, they call that phone number and it just rings and rings and rings because that's the phone number for normal situations. So they can't get a hold of the vendor to have the vendor abide by the requirement in the contract that they do the stat within 2 hours, come and pick it up, etc. And they have no other telephone number, so all they can do, supposing that situation, is monitor the patient, make sure nothing bad happens, wait until Monday morning, call the regular number, and complain. Nothing serious happened to the resident, and the stat test was picked up with a normal specimen on Monday. The contractor was called and told of the non-performance of the stat contract provision. Contractor apologized. And guess what? We should have given you a different phone number for weekend and evening situations than the one we gave you for normal testing, because our local Baltimore lab isn't open on weekends, etc. So we should have given you the number for the Washington lab, not the Baltimore lab. We're bad. Sorry, won't happen again. Now that it's straightened out, now that you have the telephone number for the Washington lab, this won't happen again. Okay, so far so good. And then, even though generally you go years between stat situations, it happened just by coincidence that about a month later, there was another stat situation that occurred on a weekend. And now we have this telephone number for the Washington, D.C. lab. So no problem, we're going to call the Washington, D.C. lab, and they're going to come up and pick up our specimen within 2 hours as per the contract. So the nursing staff calls the vendor, telephone gets answered. They say, okay, I'm nurse such and such from Spring Grove. We have a stat situation. You need to come up here and pick up this specimen for immediate testing. Who? What place was that? Spring Grove. What's Spring Grove? I don't know who Spring Grove is. Spring Grove is a state hospital up in Baltimore. We don't serve Baltimore. Why are you calling us? And, well, this was the number we were given to call on weekends. I don't know anything about that. And so the bottom line is nobody came up from the Washington, D.C. office to pick up the stat specimen to do the testing, even though there was this contract requirement that they had to do it within 2 hours. And so, of course, what they do, since they couldn't get someone to come and pick up the stat testing, the resident was watched closely for the rest of the weekend. Fortunately, nothing happened. And on Monday, the test was picked up with the normal activity. You've heard this story before, and it's tested, etc. And then Monday, the contractors called again. And here you gave me this phone number for the DC lab, and the only thing different between this time and the last time is at least it got answered this time. But I still didn't have anybody come and pick up the specimen. This can't continue to happen. And the vendor said, sorry again. We forgot to tell the Washington lab that they were now going to take up this requirement if there was a call from Baltimore.
Close them down.
And you see, the situation is, this is all well and good, but when you needed something to happen, it wasn't happening. And if something would have happened to this patient, then not only would the state have been sued, but probably the vendor would have been sued as well. So it's in both interests for this type of situation not to happen. So the contractor swore that the entire situation had now been resolved and any future stat tests would be handled properly, and went back to the normal situation for the duration of the contract, remaining duration of the contract, no more problems. So we never had to test whether the DC office would now respond. So now I'm going to pose the question to you. What would you do to ensure this situation wasn't repeated during the contract that is still in place and under the next contract? And if you look at your slides, you'll say from here on it says deliberately left blank. So this is a question for you to volunteer some answers. What would you do? Yes?
Well, number one, I'd get to the president of the company that indeed would not happen and full liability would be assumed that by then if anything occurred. And then number two, I would run tests on it. And if the test didn't go again, I'd terminate the contract.
All right, number one, you're going to follow Gary and you're going to get the phone number of the president of the company. And number two, you're going to test it.
And if it failed, terminate the contract. I don't care how good it works.
All right, were you going?
Testing the phone numbers is a good point because we had some items that we needed in emergency situations, and we basically pick up the phone and call and place an order. Well, we picked up the phone and called to place an order, and the phone line was out of service. So I definitely recommend checking those numbers.
Yes.
I would have, on the first occasion, asked through with the CEO for a plan of correction, once they had time to, because these kinds of things have to be looked into on their end as well, what went wrong, et cetera, et cetera. Get the plan of corrections, it's all in emails, so have it in writing, and hold them.
Plan of correction so that it won't happen again.
I want a written plan of correction.
Written plan of correction.
Submitted usually, I'll say by 4 o'clock that day.
Okay, I want it now,
Right.
in writing.
They know it's a heavy duty issue, whatever it is, whether it's stat blood work or pharmacy or whatever.
Okay, a hand in the back I thought I saw? No? Anybody else? Do you all agree with this? These procedures?
Yes.
So that's what you would do in the remaining of this contract? What would you do in the future? Yes?
Make a stipulation that all stat labs are reported in a certain time frame.
All stat labs, what again?
Would have to be reported. I work at Clifton T. Perkins, and our labs have to come back to us within 5 hours. From the time we call them in until we get that report.
Okay, so they have to actually conclude the test within 5 hours.
We have to get the results back within 5 hours.
Okay.
If the medical clinic's closed, it has to go to the nursing supervisor's office because there's always an on-call physician at the facility.
Okay. Anybody else?
So couldn't you get like a letter of agreement between both labs, you know, when they submit the proposal?
Get it in writing?
Yeah.
Okay, yes. Okay, yes.
What about putting something in that if for some reason you can't reach any of these labs, that you can go out, pick a lab of your choice, and then have them incur the expense?
Provision that says in the case you can't, that you have the right to go to a different lab of your choosing, and you will bill them for whatever cost is incurred by going to that other lab?
That's a good idea.
Yes. Anything else?
Might do some liquidated damages.
Liquidated damages? We might do that, especially when we talk later about what they are. All right, let's see what our studio audience from the last time we did this had to say. Answer for the remainder of the contract. Periodically call the DC lab on weekends and evenings to ensure that there is acknowledgement that if needed, the DC lab would send the driver and van to the facility for a stat pickup. Excuse me. Since we have nursing staff on duty 24 hours, 7 days a week, this is not a hard thing to do. Just at all shifts, call the DC lab and say, this is Spring Grove again. Okay, do you know who we are? If this would have been a real emergency, would you have been on the road by now? And just see what they say. And hopefully they say, yep, we know who you are. Believe me, it's come from the president of the company, because Gary has called already. And we know we have to respond to Spring Grove. All right, so that would be for the remainder of the contract. For the future, and this is actually what was done. The next time a lab contract was put out for bid, it contained the same stat provision, the same contract requirement. However, with their bid response, all bidders were now required to identify the specific lab location or locations that would provide all stat testing, including weekends, holidays, etc., and a telephone number for each. And I guess now you can even have email addresses. And they had to provide 2 references of locations that had actually used those specific lab and those lab locations for stat situations, so that we could go and validate from these references that yes, they had called this lab, whether it be on a Saturday night, a Monday morning, whenever it was, whether it be on Christmas Day, and the vendor had responded. So we have not just a hollow promise, we have evidence that it had occurred. Vendors were told in the specs that the 2 references would be called to verify satisfactory stat performance. The telephone number for the vendor stat testing lab location would be called, this is in the specs, would be called to verify that they were aware of the bid. This is even before the contract is awarded. Just are they even aware that there is a bid that is going to name them as a location to provide stat services? They were aware of the bid to provide services to the facility in Baltimore 24/7 and are prepared to respond. The bidder would be deemed non-responsible, not non-responsive, but non-responsible, not capable, if the two provided references didn't verify use of or satisfaction with the lab stat locations, and if the identified stat lab location did not confirm intent to perform stat pickups in Baltimore, if the lab company should win the new award. And I think we went beyond that. The facility diligently checked all references and telephone numbers from then on. The central office procurement staff was never informed of another problem. May never had one, or maybe this situation took care of it. So that was what we had done. And that was, again, about 89 of 90, something like that. And I left DHMH in 96, and for the next 6 years, I never heard of a problem. So either there were no problems, or this procedure took care of it. I don't know, but it never got to me again. That's all I know. And that's what we did. And frequently, this is how you learn to do contract management, because something didn't work. And once it doesn't work, you know you have to do something different so that the next time, the old fool me once, shame on you, fool me twice, shame on me, the next time it doesn't occur like that again. You try to do what you can to prevent a repeat performance of something that you don't want to be repeated. Let's see. All right, at this point, we should take a break.